Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. Another short video. Amicus curiae, Latin for friend of the court. Well, technically it's friend of the courts because curiae is the plural of curia, which is the singular court. But over time, amicus curiae has come to mean friend of the court. What is a friend of the court, and when do they show up in cases? An amicus curiae, or simply an amicus, often also pronounced amicus, but I lean amicus, usually becomes involved in a case when the issues at stake in that micro case affect a larger swath of society and not just the parties to the case, and the wishful amicus, who belongs to that larger swath and has an interest in the outcome of the case, asks to be the court's friend and weigh in with a brief, taking the position of one side or the other. For example, if someone is suing their homeowners association over crabgrass fees, and a decision in that case could forever affect how homeowners associations address crabgrass, the made up for this video Society of Helpful Homeowners Associations may ask to file an amicus brief for the homeowners association, adding argument to their side of the case. An amicus is considered a friend of the court because there's no other way to categorize them. They're not formally intervening in the case, expecting any award of damages from anyone, because they don't have standing, which is just a formal way to say they don't have an actual stake in the micro cause of action, so they're not allowed to join the litigation. But they are hoping to speak within the cause of action and affect the outcome of the litigation, so their seat at the table is as a friend to the court. They're purportedly helping the court decide the case. You might think that amici, plural for amicus, participate in strictly newsworthy cases litigated on the national stage, but that's not the case. Cases that get virtually no attention from the media may still draw the attention of proposed amici who have an interest in the outcome of the case. Think of our homeowners association and crabgrass example. That's probably not on the national news, but you could nevertheless have one amicus or multiple amici who seek to weigh in on that case. So while 140 amicus briefs or amicus briefs were filed in Dobbs versus Jackson Women's Health Organization, decided by the United States Supreme Court in 2021, dominating news cycles at the time and contributing still to elections discourse around the country, a more localized case may have just one or two or three amici. Likely only court staff and the litigants know the amici in those cases exist. Sometimes a court will invite an amicus or several amici to file amicus briefs, but usually it's the amicus or the amici who ask to file an amicus brief. They want in. Depending upon the briefing, a court may even allow amici to argue before the court when the court reaches the oral argument phase. Final fun fact. The United States or its agencies can file amicus briefs in federal cases without asking permission of the court or seeking the accord of the parties. The government can just drop into any case it feels requires its input. Meanwhile, different states empower their state attorney general to exercise a similar privilege. So attorneys general around the country may have the same power to airdrop into cases that the Attorney General believes the state should be weighing in on. And there you have it, amicus curiae, or amicus curiae. If this was helpful, please hit that like button. Links to my other trial watchwords are above and in the description. And it bears repeating, nothing in this video is intended to be legal advice to anyone about anything. Thanks for watching.